Welcome back in Live Now. I'm Austin Westfall. Well, you know what the big story of the day was. Hunter Biden has been convicted of all 3 felony charges related to the purchase of a revolver in 2018 when prosecutors argued the president's son lied on a mandatory gun purchase form by saying that he was not illegally using or addicted to drugs. He faces up to 25 years in prison, but no sentencing date has been set. Let's discuss this with former federal prosecutor Neama Rahmani. As always, Neama, thanks for being on tonight. Let's get straight into it. There's a lot to cover today. So first off, we've had 2 quote-unquote unprecedented trials conclude in less than 2 weeks. I remember when the Trump jury was deliberating, it certainly felt like there was a sense of uncertainty about which way the jury would lean. This one, however, felt a little different. Were you surprised by today's results?
Not at all, Austin. And you're right. We're talking about 2 historic verdicts, but this one, in my opinion, was a mere formality. Hunter Biden should have accepted that plea deal to plead guilty to 2 misdemeanor counts and have the gun charges resolved by a felony diversion, which is rarely offered in federal court. And folks were rightly critical of it. Some called it a gift or a sweetheart deal because there was no real defense in this case. And we've been talking about it every night. It was clear that Hunter Biden was addicted to crack cocaine. It was clear that he was both using and addicted when he filled out those ATF forms and took possession of that firearm. So for the defense to try to credibly argue that Hunter Biden, who is a lawyer and who went to Yale Law School, didn't know what he was doing when he signed those forms under penalty of perjury and took possession of that firearm, that really defied all logic and credibility. The only chance the defense had was maybe a holdout juror too because of sympathy or politics, but they followed the law, they got it right, and that didn't happen.
So the maximum sentence, as I mentioned, is 25 years, but given the fact that this is his first offense, we aren't expecting the max amount, but how likely does it feel that we'll actually see Hunter get any prison time? Could he, say, just get a fine?
I think he's likely going to get probation, maybe home confinement. And like you said, this isn't the most serious offense. It's rarely prosecuted. It was obviously offered to be disposed or resolved for a slap on the wrist. So for Judge Norica to take the unprecedented step of jailing the son of a current president with Secret Service protection and the Bureau of Prisons, logistically, just a nightmare. And obviously, it's going to be her decision, and who knows what she will do. There's not a lot of history of her sentencing criminal defendants because she is a recent Trump appointee that doesn't have a significant criminal background. She was a patent attorney before she took the bench. So it's too early to tell, but if I were a guessing man, I would sentence probation, maximum home confinement. I don't think we're going to see a sentence of imprisonment here.
You alluded to this at the beginning of the interview. Let's remind the audience, just how close were we to not even seeing this trial take place at all?
This is very important. So last summer, and a lot of folks were upset, especially Republicans in Congress. Hunter Biden was offered a diversion agreement by David Weiss before he was special counsel, and I'll explain why that's important. He was offered to plead guilty to 2 misdemeanors, pay a fine, get no time, and if he kept his nose clean, the gun charge would be dismissed. That was part of the diversion deal. People were up in arms because diversion is rarely offered in federal court. I can tell you when I was a federal prosecutor, I put more than 1,000 people in prison. I never once offered a diversion deal. But Hunter Biden's lawyers, they got greedy. They announced publicly that this resolves all criminal investigations into Hunter Biden. And there was a reason that wasn't true. The U.S. attorney at the time was David Weiss. He didn't have jurisdiction over FARA violations in D.C. for Hunter Biden's failure to register as a foreign agent for Ukraine, if those allegations are true, or the tax crimes in California, which is currently scheduled to go to trial on in September. This was before David Weiss was special counsel. So when the judge in the case, Judge Norica, during the plea agreement hearing said, well, the defense is saying this resolves everything. The government, is that true? The government said, no, it's not true. And then the defense said, we don't have a deal. So they walked away from the deal. Hunter Biden's lawyers made a huge mistake. They put Hunter, their client, through this embarrassing trial where there was no real defense whatsoever. They embarrassed him, they embarrassed the family, and for what? Now he's convicted of 3 felonies.
Let's also get into that case that you're talking about in California, because that's something that we're going to be watching for later on in the summer. Hunter Biden is set to return to court later on in September. This time, we're going to be talking about him being charged with 3 felonies and 6 misdemeanors concerning $1.4 million in owed taxes that have since been paid. That trial will begin in September. Do you see that trial impacting the gun case sentencing eventually, or vice versa?
Vice versa. So to the extent that Hunter Biden is sentenced, and he will be, and he has a conviction, that is going to affect his criminal history category. No longer going to be a criminal history category 1. Under the sentencing guidelines, what matters is the advisory sentence. And people talk about the maximum 25-year sentence. Well, no one gets near the maximum sentence. It's really based on a series of calculations under the guidelines that gives federal judges a range. That range is advisory, but oftentimes judges will stick to that range. And in this case, it'll probably be months in custody, but again, judges can deviate from that or do home confinement in lieu of custody. Well, in the tax case, because now Hunter Biden has a felony conviction, actually 3 of them, and is going to be on probation or potentially supervised release, he's no longer going to be in that lowest criminal history category. He might be in a criminal history category 2 or even 3, depending on the nature of the sentence. So that's going to increase his range if and when he's convicted of tax crimes in September.
So in the Trump case, and I'll bring it back because I can't help but draw comparisons between the 2 cases that we're talking about so often here as of late. In the Trump case, we got the sentencing date pretty much right off the bat. Why is it that we sit here tonight and we don't know when the sentencing is going to happen for Hunter?
Well, oftentimes at the verdict stage, if there's a guilty verdict, the judge will issue a date for sentencing. I expect it to probably be around October, so it'll be before the election. Now, the defense may try to move it past the election, saying they need more time. And the reason is this. Just like Donald Trump recently sat down with probation to do his probation interview, Hunter Biden's going to have to do the same thing. He's going to have to meet with U.S. probation, and they're going to prepare a pre-sentence report. They're going to talk about his employment history, his criminal history, his addiction, of course. And probation, which is an arm of the court, is going to make a recommendation. So at the sentencing, we're actually going to have 3 sets of recommendations. The prosecution, the U.S. Attorney's Office in Delaware, the Special Counsel's Office, they're going to make their recommendation. The defense, of course, is going to make their recommendation. They're going to ask for no time. And probation is also going to make a recommendation of its own based on the U.S. sentencing guidelines in the unique characteristics of this defendant, Hunter Biden. So the judge is going to consider all 3 when deciding what the appropriate sentence is. So it's really all going to come down to Judge Norika, but she's going to have all 3 parties consider their recommendation.
So I was reading just yesterday that Donald Trump was interviewed by a New York probation officer ahead of the July 11th sentencing for that federal conviction. Do we eventually expect to see Hunter doing the same? What's next for him in this process?
Yes, Hunter will do the same. Now, he'll have his attorney present, and the attorney may advise him not to answer certain questions. But again, we're talking about things that Hunter Biden's already admitted. He's written in his memoir about his addiction to crack cocaine. He's talked about it in open court as recently as 2019. So these aren't things that he's going to be able to get away from. Now, he may have some arguments on appeal, certainly better arguments than he did in the trial court, but I don't think any of those will be affected by the probation interview or the sentencing. And those 3 arguments on appeal are as follows. First, he's going to argue that the government should have been bound by that original plea agreement, and they breached it. Now, of course, the government's going to say, well, we didn't have a deal. You wanted the deal to cover everything, and we wanted it to only cover these gun-related charges. But there at least is some precedent for this type of appeal. I'm not going to say it's a winner, but if folks recall, Bill Cosby's conviction was overturned on appeal because the Pennsylvania Supreme Court said that the previous district attorney had an agreement with Cosby and Cosby's lawyers not to prosecute him. So when a subsequent district attorney took over and decided to file charges, they breached the plea agreement. So they unwound that whole conviction. The second argument that the defense is going to make on appeal relates to the constitutionality of the statute itself. So a lot of Second Amendment advocates believe that this type of statute is unconstitutional, and there at least is some precedent for that argument. There's a Fifth Circuit appellate panel in Texas in the U.S. v. Daniels case that recently ruled that addict in possession is unconstitutional to the extent it says that former addicts can't own firearms. Now, that case involved marijuana, and the facts were very different, of course, but the defense is going to challenge the constitutionality of this law. Judge Norica overruled that objection, but it's going to go up to the First Circuit. So to the extent that there's a circuit split between the Fifth and First Circuit, this case may end up in the Supreme Court. And of course, just like Donald Trump did, Hunter Biden's going to argue that this was selective prosecution and this was vindictive and this was all political. We know that that might make for good politics and news interviews. Very tough to win that argument in court, but that's an argument that I also expect the defense to make on appeal.
When do we expect to see the appeal process start moving?
So as soon as Hunter Biden is sentenced and that judgment is entered, the defense has 30 days to file their notice of appeal. That just starts the process. Then the case will go to the appellate courts. They'll set a briefing schedule and oral arguments, but that's not going to happen until well into 2025. So the results of that appeal won't happen until well after the presidential election.
All right, Neama, we will leave it there for now. As always, we appreciate your insight. Take care. Have a good rest of your night.
Of course, Austin, you too.
All right. Let's slide away for a quick commercial break. We'll be right back in 2 minutes.
I'm Heather Sullivan with Sullivan Smart Sense. Rental